I'm barely live, my ghost, so it doesn't count. Martha, my love. Do you need a nurse? I could come down there. I could. I think you need people to lift everything for you. Do you want some more water? Do you want another hit? I could come down and be your hit woman. I could take care of you. Michael has one good hand. He can come with me. Maybe you and I can get his other hand working. What do you think? Wait, Michael, is the hand still attached? Or is it a hook? If it's still attached, me and Martha can get it working again. I saw Grey's Anatomy. It's fine. I saw The Pit. I saw all the episodes of House, so I'm overqualified actually. So, but if it's a hook, then there's not much I can do. I know. I would love to. I just feel like you need someone just to lift the stupid stuff. Like, I need to get something, but I don't feel like asking for someone to do something this stupid. That would be what I'm there for. To do the stupid things you don't want to ask anybody. So, we still don't know if Michael has a hook. He's not telling us anything. How are your feet, Michael? Do your feet work? Or is it just your one hand? Anyway, Dwight, I haven't seen you in a while. Hi, Dwight. All right, guys. So we had that case. Michael, what is a pirate's favorite letter? I've said this joke, I think, 4 times before. Everybody should get it right. What is a pirate's favorite letter? Okay, so we did this case before. This was the case. But I told you I would get more. I would get sentencing. I would get updates. So we got a sentencing today. We're gonna go with Hunter and Mason into the sentencing, and I know it is not an R, even though they say R. It's the sea. They have a love for the sea. A pirate's greatest love is the sea. Anyway, that's number 5. At one point in my life, I'm going to say that joke, and everybody's just going to flood chat with C's. Yep. All right, we're going to go to this update, this Georgia case. We're going to get a sentencing in. And then I got lots of more stuff. Do not worry.
2 families' lives have been totally changed.
Oh, I forgot. Sorry, it's hard when you go live and you have words you think you're going to say, and then you just don't. There was a victim impact. There was a whole bunch of victim impact statements before this, from both sides, from his side and from the other side. And he was not found guilty of murder and not found guilty of murder. He was found guilty of aggravated assault. So that's what they have to sentence him on, just aggravated assault. If you want to hear the victim statements, the victim impact statements, and everybody talk about, how it's affected their lives, I did put that whole clip up in the members only area so that you guys would have access to it. I'm not going to play it here though. It's sad. It's very sad. So I'm going to, there we go. Got my chats working, and now I'm going to press play.
Mason McCarty family will never be whole. There's no way that we can make it whole. There's a terrible loss there, and we're deeply, deeply sorry. Mr. Kersey is a young man. He's only 30 years old. He's been a good citizen. He read and heard statements and stuff of what a family man he is, what a friend he is, how hard he works, the family business, and the jury, we can't argue with the jury verdict. The jury has returned it. And you've heard all the long evidence, and the jury returned the verdict of aggravated assault. And we realize that there's going to be punishment. There's going to be a sentence, and we throw ourselves on the mercy of the court. That the court make the sentence as light as possible. Mr. Kersey, he's never been a felon. He's never been a violent man. We ask the court to give him first offender treatment on the sentence that the court imposes. And we'd ask that the court impose a sentence of probation in this matter. Mr. Kersey is not a danger to the community. He's been out on bond for 2.5 years before this matter even came to court, with absolutely no incident whatsoever. And Judge, we just plead with the court to allow Mr. Hunter Kersey to remain out of confinement so that he can support his family, work, and be a productive member of society under whatever conditions the court imposes. Thank you.
Pritchett, on behalf of the state.
Thank you, Your Honor.
And I also found out this judge's name is Kaufold. Kaufold. Judge Kaufold. I'm probably never going to call him that. I'm going to call him whatever comes out of my mouth when I start talking.
The state certainly opposes probation in this matter. The state is going to ask the court to impose the maximum punishment of 20 years in prison in this case, Your Honor. There's a lot of irony in what you heard today. We also would agree that we're not in any way trying to impeach a jury's verdict. We can't argue with that. We're here because they found him guilty of aggravated assault. He didn't show any mercy that day on this young man, Mason McCarty. As you've heard from several family members and friends of the family, that this young man's life was snuffed out. And you can't separate the fact that his life is taken. I mean, it's just the facts of the case, although he's not been found guilty of a homicide. But, Your Honor, he is no longer going to be able to do stuff with his kids. He's not going to go to rec ball games or travel ball or anything like that with kids. He's not going to go fishing and take them hunting and be able to do stuff with his kids. He's not going to be able to go to these family gatherings that his stepmama talked about. He's not going to be out there grilling the steak with his people, or out there hanging out with loved ones, or going mud bogging, or going to whatever hobby it is, whether it be golf or whatever it may be.
What is mud bogging? Is it like when I am guessing because I do not know, so please do not think that this is what mud bogging is. Is it when you ride your little four-wheelers through mud piles? Is that what mud bogging is?
Not going to be able to do anything ever again. He's a son, a father, a brother, an uncle, friend, a grandson. He was, whether or not you like his actions that day, he is well loved, and you can tell by the group of people behind me right here that that's the case. And I'm not no doubting that Mr. Kersey has also got a lot of love in his family, but he made a terrible choice, and he should have consequences, Your Honor. And what speaks what's one of the concerning things about, we hear that he's got remorse or sorrow or whatever, but I don't think that's ever been expressed. He just let that man out there like roadkill. He just left him out there on that road. And just as the stepmama said a while ago, like a dead deer on the road. I mean, he just left him out there like a carcass. Everybody in these statements and all, you hear how helpful he is and how much he wants to do. But if you ask him to help pull somebody out of the mud, he wasn't helping with that boy. He just flat out refused to help him, and it resulted in a killing. Or an aggravated assault, which is what the court's got to consider. He got shot over asking somebody to pull him out of the mud. And you heard him in that statement that he made to the GBI. He started out so casual, talking about guns and fascination with the guns that the officer used, and talking about rifles and such, and ends it on talking about
Monica, thank you so much. People love memberships. All those people are going to be super stoked when they see their email. Thank you.
Doggone cologne. And that does me not sound like a person who's remarkable. It's not somebody, somewhere it was woven in there at some point in time during that statement. Some discussion was made by GBI agent Corey Haynes about the status of the young man and how he was going to do it. And it did look like it would look pretty grim.
I say mud bogging and Josh shows up. Hi, Josh.
And there was some reference that Agent Haynes was praying for him, and of course Hunter said something about that too. But there was not a true remorse in anything that happened that day. Again, Your Honor, you got a hard decision to make. There's a lot of irony, as I was saying in those statements. You could just about substitute Mason's name in just about everything that got read.
Hi, one badass Momo. Yeah, I had to read that name out loud. This is awesome.
To you a while ago from Hunter Kersey about not being, of course, he's not going to be with his children. He's not going to be with his family. He's not going to be in so many other capacities. And so they're asking you for mercy, but again, no mercy was shown on Mason McCarty that day. Yes, 2 family lives have been changed. And he's at the point in time where he's on your mercy. I know the court doesn't generally like to hear from the state about first offender, but we do adamantly oppose first offender in this case. We don't believe he needs to be out there at some point in time with firearms again. And we just respectfully ask the court to return a sentence that does speak the truth in this case, and ask you to punish him to 20 years in prison.
All right. In regards to the concept of first offender, I want to have a colloquy with Mr. Kersey to make sure he understands and appreciates the potential or future ramifications
Martha, do not wave back. A head nod is fine.
of that concept. And
Yes, sir.
I like to put that on the record. Is there any objection from the state in that?
No, Your Honor.
Mr. Pittman?
None, Your Honor.
All right. Mr. Kersey, if you would rise for the purposes of the colloquy as to first offender, I'm going to put him under oath, and solely for that purpose.
Yes, sir.
State understand?
Yes, Your Honor.
Any objection, Mr. Pitt?
No, Your Honor.
Mr. Kersey, if you'll raise your right hand for me, please. Do you solemnly swear or affirm that the testimony you're about to give to the court as it relates
Thanks,
concept of first
Kelly.
offender and your understanding thereof to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Are you requesting first offender in this matter?
Yes, sir.
Have you ever been convicted of a felony prior to the day?
No, sir.
And has Mr. Pittman gone over the conditions of a first offender with you? And you understand that the concept of the first offender is a once in a lifetime opportunity?
Yes, sir.
I want to make sure you understand that if this court sentences you as a first offender of probation and you violate the terms of your probation, the court at the time of that violation of your probation, the court can adjudicate you guilty and proceed to sentence you to the maximum sentence provided by law in this case.
Yes, sir.
Meaning that you could be sentenced to 20 years. You understand that?
Yes, sir.
Additionally, I want you to understand
Jude. Oh, where's my camera? I'm trying. Jude, thank you so much. I appreciate it. Thank you, Jude.
that if an adjudication of guilt isn't, you may be sentenced to a greater sentence than that which I may impose here today, and a sentence that is more restrictive than that which is imposed that may be imposed here today. Do you understand that?
Yes, Your Honor.
Meaning that regardless of the sentence that I impose here today, you come back before this court because you have violated your probation. This court could sentence you to 20 years with the Department of Corrections in regards to this case. Do you understand that?
Yes, sir.
However, if I do sentence you under the first offender, you would be given credit for the time that you have served under this case in regards to any new sentence. And ultimately, if you complete
Not probation.
this sentence that I impose here today under the First Offenders Act successfully, you will not have been convicted of a crime in this matter. Do you understand that?
Yes, Your Honor.
Now, if you can, I'd like to hear why this court should consider you under the First Offender Act.
Your Honor, I pose no threat to the community whatsoever. I have 3 loving children and a wife that I have a need to take care of. I also, grandparents, elderly, I strive to take care of them. There's really not much I can say to you, Your Honor, to convince you any way, left or right. I feel that I'm not a threat to society, Lord, Your Honor. I'm sorry, my nerves, I'm shaking. I don't know the words to say right now. I feel I'll do good in society. I feel like I'll be beneficial to outside. I don't feel like I would cause any harm.
All right? Anything else? Mr. Pittman, do
No,
you
Your
wish
Honor.
to say something?
No, Your Honor. And with regards to the first offender, at some point in time, Your Honor, and I've talked with Mr. Kersey, and I know he's at a loss for words now, but he wants to return to society with his rights where he can get employment and maintain employment without a felony conviction hanging over his head, and keep his life clean and straight.
Keep his life what?
Clean and straight and be a productive member of society.
So if I remember correctly, and you guys can tell me if I'm wrong. Hi, Casey, Gary. So, all right. One guy got his truck stuck in the mud, and another guy went to help the guy get his trucks out of the mud, and he got stuck in a ditch. And then the sister of the guy who got stuck in the mud, she got a phone call from the guy who got stuck in the mud that she's currently banging, but she's dating someone else. And she said, no, I'm not coming to pull you out of the mud. I got to go somewhere for my mom or my grandma or whatever. I got to take my grandma's trash out. She had to go pick up her grandma's trash, which was a lie. And he said, yeah, but if you don't come and pick me up and get me out of this mud, I'm not giving you this good dick anymore. And she said, I don't care. Okay? And then the guy who got stuck in a ditch going to help the guy get out was actually her brother. So he called his sister and he said, "Sister, I'm stuck in a ditch. Will you come pull me out?" She said, "Bet. Absolutely will come and pull you out." This is the guy who came to pull. This is his sister's boyfriend. All right. So he drives up to Justin, I think is the name of the guy in the truck that was stuck in the ditch. As he gets up to Justin, the guy who's stuck in the mud hops on his truck, hops on like the driver's side part of the step, and they start fighting, and he's punching the guy driving, and the guy driving is trying to punch out the window at him. Well, the guy who drove there, Tyler, I think his name is, I don't remember though, he brought a gun to this fight, but I don't know, they didn't really say. I don't know if he brought the gun because he knew Mason was going to start pounding on him. I don't think anybody knew Mason was going to start pounding on this guy, but he did. Mason got shot in this. Whether it's accident or not, the jury found that the driver of the truck was not guilty of murder, but is guilty of aggravated assault, because when this guy got shot, he laid there and then he died. They left the scene. They left the scene. Now, they didn't leave him there alone. This sentence makes it sound like they left him there all alone to die, and had he stayed, he would have lived. No, there was lots of people there. There was Justin in his truck. The neighbors took their four-wheelers, and they were right there when they heard the gunshots. The neighbors on their four-wheelers, they ran on their little four-wheelers as fast as they could. The sister was in the back seat of the truck, I think. She made Tyler call 911 and report what happened. And 911 said, "You need to stay there." And then he said, "Oh, no, I don't. I don't want to get attacked anymore. I don't feel safe there. I'm going home. This is where I'm going. I'm going home." So he went home. And so Mason is the one who threw the first punch. Mason is the one who died. This guy, I think this is the guy who drove the truck and brought the gun to this pulling out his sister's brother from the mud, and because he had that gun on him, that's why Mason got shot. Does that make sense?
All right. Anything else anybody has to say?
No, Your Honor.
All right. Y'all excuse me for just a few minutes and let me ponder my task.
Yes, Your Honor. Yes, sir.
He doesn't ponder like Eric ponders, guys. Now, he never came back on. However, I do have the verdict. He was sentenced to 20 years to serve 5. Okay? All right. There was a lot of stipulations to his 15 years of probation, though. He is subject to random searches at any time of the day or night. And if they find anything on him at all, at any point during his 15 years of probation, then he has to serve the entire sentence in jail. Hi, 34. Anyway, so he gets to try probation. He gets to try first offender. If he really is not a threat to the community, if he really doesn't break the law anymore, then he has to serve his 5 years first in a Georgia prison. Yes, he does get credit for all the time he served on probation when he violates, if he violates. Of course he's going to violate. Nobody's perfect. Yeah, there's no picture. I got to start the next case. So we'll see. He's going to be incarcerated for 5 years. That's where we're at now. Here we go. Picture.
I just said dumb as hell. I said that was dumb as hell.
You said I was dumb.
Okay, well, you're putting words in my mouth.
On camera, though.
Oh, it is? All right, bro.
Are you recording?
Yeah, you're supposed to.
All right, it's on camera.
Okay, yeah. Record me then.
Why not put a gun on that? too?
Do it. I don't care.
Talk about that shit. We don't do uniform and shit.
No,
Yeah, that's what
shit
it
don't
is.
matter to me, bro.
That's what it is.
No.
Then you want to ask, what am I going to do?
Well, you want to threaten me and shit.
I train? Or you threaten me?
Really?
Come on.
How about threaten you?
What are you going to do?
Yeah, because you
So
said,
you ain't threatening me?
yeah, I asked you what you gonna do.
Well, now it's what you going to do?
All right, bro.
That has absolutely nothing to do with the case we're about to see. I just thought it was pretty cool, an inmate getting in a fight with a guard.
Oh, ain't you? Yeah, well.
Okay.
A verbal fight. No one's going to fight.
Commented video rate. On the video. Other two on like wow.
Get your workers.
Thank you.
We're here in a series of causes titled State of Indiana v. Michael Pittman. That's 50D03-2403-CM325, 50D03-2405-F529, and 50D03-2505-F6137. And Mr. Pittman is with us via the jail video. His attorney, Mr. Ariano, is with us in court in person, and the state's here by Chief Deputy Prosecuting Attorney Nicholas Langowski. And Mr. Ariano, we're set for status this morning. What is the current status of these cases?
Yes, Your Honor. We are we have done a lot of groundwork and covered some ground, I guess, in resolving all 3 cases here before the court. At this time, I'm going to ask that we set level 5 matter, 2405 F5 29.
He struggles with his audio, but the judge also can't hear him well. So the judge repeats back everything he says to make sure.
For a jury trial?
The F5 cause, you said?
Yes, sir.
And what's the time frame you want the trial scheduled?
Whenever there is a specific time frame.
All these words, all he's saying is whatever's best for the court. That's his answer.
Resolution or resentence up to the court.
So what I'm hearing is set a trial in the level 5, but he intends to plead guilty in the other causes.
That is correct, sir.
Okay. I have June 3rd available.
That'll work.
Does June 3rd work from the state's calendar? Or did someone cover?
For the trial and that
Yes.
Yeah, the June 3rd would work.
Okay.
Dwight, it's good to see you again. Thank you so much. Thank you. They only sent 4. Do you see that?
And Mr.
You guys have
Ariano, do you
5?
anticipate Mr. Pittman pleading guilty prior?
Dwight, YouTube just ripped you off, buddy. 1, 2, 3, 4. Oh, because you sent one to a Kara, almost Karen. They said, no way, man, no more.
Prior to the trial or after the trial?
Prior to.
And that's obviously in the other causes.
Yes, sir.
So what I'll do then is schedule the 50D032405 F529 for trial on June 3rd, 2026. And then I'll schedule a status hearing approximately a month from now and a month before the June trial date.
They will send another one at some point, Dwight. It comes up later sometimes. I don't know why.
That'll be scheduled for May 7th. And the status hearing will be scheduled in all three causes. Obviously, it'll be a jury trial status on the F529 cause. And then there can be some discussion about where the pleas sit in the other cases in the event that he's not pled guilty in those other two causes.
Yes, sir. I anticipate that we'll have the signed agreement filed before the court before then.
I'll let you move forward with it right now.
Well, Mr. Pittman, I appreciate that. It's just that we have a series of cases scheduled today, and Mr. Ariano likely needs to have you coordinate with the probation department for a PSI and written report. And I do appreciate you wanting to take responsibility today, but logistically, we don't have the feasible time today, but also we can do that all at one time where you plead guilty and then are sentenced once we have the PSI and written report. So it's just more time efficient, but also it gives Mr. Ariano the tools to argue for your case in the CM and the F6 cause. And all of that can be done well before June 3rd. So it's not as if we're trying to delay this any further. It's just making sure that it's most time efficient.
Most time efficient on whose time? My time or your guys' time? Because my time's valuable too, just like you guys' are.
You're in jail, sir.
I understand that, Mr. Pittman.
I'm trying to be respectful and everything. I'm not trying to be disrespectful. I've been here almost a year and everything's been getting postponed and postponed. I still haven't received my motion for discovery on any of my cases or anything else like that. So I've
given you a copy.
No, you have not.
Right. Well,
you have not given me a copy of my motion for discovery. I've asked for it and you said I don't have a right to it.
Mr. Pittman, it's probably in your best interest to not have this argument here in open court.
Shut up, Judge.
What I want to reiterate to you is this. Mr. Ariano recognizes that you want to have this matter resolved, at least two of these matters by plea. I indicated that we're setting them for status on May 7th. However, he also indicated he's going to schedule that earlier than May 7th. And then also we need to have the PSI and written report completed. In your F5 cause, there's going to be the jury trial scheduled for June 3rd, 2026 at 8:30. So you know that that'll be the disposition date for the F5 cause. However, you will be before the court for a plea and sentencing hearing before May 7, 2026.
Well, I hope it's very soon because I'm tired of sitting here and I'm tired of waiting. Every time I turn around, my court date has been changed for some odd reason or another. I understand.
Do you want to know why his court dates keep getting changed, guys, for real? He has many cases going forward. Okay? And he's going to trial on some, he's pleading to some, and he keeps picking up new cases. So every time that happens, everything, they're trying to intricately weave together into something comprehensive, gets blown to hell, and they have to start all over again. So that's why. That's the reason why.
The snow day and everything else, but I don't understand all the other ones why it's been changed. And I haven't spoke to nobody or anything. I just recently got a whole back.
Never have I seen that before, guys. Guys, look. Dwight gifted 10 memberships. Thank you very much, Dwight. I appreciate it. And the first person he got was himself. That's pretty cool. Does that happen? Is that a thing? I've never seen that before, but maybe that's normal. Maybe, of course, that you get the first one. Now that I say it out loud, it just makes sense, but I've never seen it before.
I told him, Mr. Ariano, just recently, and I was under the impression that I was supposed to be pleading guilty today on the two cases and everything, and
I don't think Mr. Pittman is wrong, Your Honor, on that. He was under that impression, and that is what we did, Mr. Pittman. We came this morning and let the court know that you are going to plead guilty Judge is just setting it for another status because we need that PSIR done, and we need to have the open agreement actually filed.
I've already done one. I've already went through the courts. I've done one when we first started this case.
We just talked about this a couple of days, about your demeanor or how it will help you or affect you, so I would recommend holding off.
Well, I still want my motion for discovery.
Ariano's represented you here, and it's not him that's saying he doesn't want to go forward today. To be clear, I have over 50 status hearings scheduled this morning, other submissions of plea and sentencing that were previously scheduled. And so as of this morning, I do not have the time to go forward with a submission of plea and sentencing, especially when it's an argued sentencing where I'm going to have to hear the argument from the state and the defense. So I appreciate your willingness to try to get this resolved, but we can't just push everyone else's cases to the side when I have these previously scheduled matters.
Well, how soon can we get this done? I'm trying to do things before the trial. There's things I got to take care of and everything else. My stuff at my sister's house that I don't, I got things I got to do too. I got to go get my teeth and everything else and all this other, and I got things I got to do too. So how soon can we get this done?
I will, Ariano, coordinate that with my staff, and we get that as soon as I have an available date. So I can't say exactly when that will be, but it can be certainly before May 7th, which is what the backup kind of as a status hearing is scheduled for, but it certainly can be before then.
I also would like to note that I want my motion for discovery on all my cases. Mr. Ariano has stated to me that I don't have a right to it, and I know that's a bunch of crap, so to speak. Excuse my French. I'm not trying to be disrespectful, lack of better terms.
Well,
and I want my motion for discovery.
Clear that that's an attorney issue, and that's not necessarily a right issue, meaning you're not entitled to the information. It is at the discretion of the attorney.
Absolutely, I have the right. Everybody else has the right to have their motion for discovery. I absolutely do have the right, unless it's shown in case law that I don't have the right. That right has been taken away from me. I want to see it.
Well, Mr. Pittman, the beauty of this is I'm not going to argue with you. We've concluded the hearings. I will see you back for the
submission. I understand that. I'm just trying to make it known that I want my motion for discovery, and this is what's being said.
I'm holding up my three fingers because
I would like to make it known, Judge, with your three fingers, that I would like $1 million. It's my right. Everybody else gets it.
3 times you've raised the discovery. I've noted it 3 times in my mind. You don't need to say it a 4th. Thank you. You can go with the jail staff or have a seat in the back.
I think the aid that he used with mathematics helped him. I just think so. I think more judges should use mathematical aids to help the cases along a little bit. I think this one might be too much. Hold on. Let's do this one. This is a charge that we have not heard before.
Is as we go forward with that agreement, and by which you would be pleading guilty to the charge listed in the plea and then being sentenced in accordance with the terms of the plea. Was that your understanding of why you were coming to court today?
Yes.
Did you read through the agreement, understand the terms, and then sign it?
There's an interpreter beside her. That's what the background noise is.
And the agreement is in fact in front of you, in front of Ms. Bueno as well. Do you have any questions over those terms before we go forward?
No.
Did you also read through the acknowledgement of rights form that was attached to the plea?
Yes.
There are certain rights that you are waiving, recognizing, or acknowledging by going forward today's hearing. Do you understand that? As you read through those, do you understand that you are waiving or acknowledging those rights?
Yes.
Additionally, listed in paragraph 1 is that you have the right to a trial by jury. At the trial by jury, you would have the right to see and hear the witnesses testify. You would have the right to bring witnesses in to testify in your defense.
I forgot to slow the speed back down on this one, guys. The speed is up to how I listen to it.
You would have the right to require the state prove your guilt beyond a reasonable doubt. You could not be forced to testify against yourself, meaning you have the right to remain silent. You'd also have the right to be represented by an attorney, such as Mr. Shinsky, at that trial. And you also have the right to an appeal. You understand you have that set of rights. And if you go forward with your plea today and are sentenced, you'll be waiving all those rights I just listed. Do you understand?
Yes.
The terms of the plea are as follows. You would be pleading guilty to the charge of practicing medicine without a license as a level 5 felony. The total sentence would be 2 years in the Indiana Department of Corrections.
Practicing medicine with no license. You're going to hear why in just a minute.
However, the entirety of those 2 years would be suspended. You'd be placed on probation for a period of 2 years beginning today's date. Not specifically listed in the plea, however, required on any sort of conviction is $1 fine plus court costs. And so the court would anticipate imposing that financial obligation of $1 fine plus court costs for the case. Was that your understanding of the agreement you reached with the state of Indiana?
So it doesn't, you can't hear everything great coming up, but what I understand is she has a salon and was giving Botox injections at her salon.
Do you have any questions or concerns before you go forward with that agreement today? Then to the charge of practicing medicine without a license, how do you plead this morning? Guilty or not guilty?
Guilty.
Are you under the influence of drugs or alcohol currently?
No.
Do you understand what you're doing this morning?
Yes.
The charge dates to January 1st, 2025 here in Marshall County, state of Indiana, where it is outlined that you did practice osteopathic medicine in the state of Indiana without holding a license or permit to do so, as provided by statute. Do you agree you committed that offense as it was charged?
Yes.
Mr. Tushinsky, in your review of the discovery in the case, as well as the testimony your client just provided, do you think there's a sufficient factual basis?
I do, Your Honor.
We can't hear him great, so it'll be quick though.
You provided service that exceeded your cosmetology license. And those services under
No, Bobby, don't. No, Bobby, I got another one for you. The next clip is for you, Bobby.
Mr. Tushinsky's been asking these questions. They've been interpreted the entire time as they've been interpreted. Ms. Kiefer, now known as Gabo, has been nodding her head in the affirmative, but not answering out loud. So that's why Mr. Tushinsky was acknowledging and going forward with his next questions. Ultimately, Mr. Tushinsky's last question was, is that correct?
Yes.
Go ahead, Mr. Tushinsky, with any further questions you have.
some of those services may include intravenous or IV therapy.
Yes.
And Botox by using injections.
Yes.
Any further questions from the state?
No, Your
Honor.
Ms. Gabo, do you have any further statement about the facts of this case, your personal background, or any other information you'd like me to know at this juncture?
No.
There was a pre-sentence investigation and written report that was filed in this case. Did you have an opportunity to review that document before today's hearing? There was a pre-sentence investigation and written report that was filed with the court. And my question is, did you have an opportunity to review that or read it?
Did you see?
Sí, sí, yes. Yes, yes, in English I did, yes.
Were there any corrections or errors that you wanted to bring to my attention?
We can take a minute.
Careful there.
My question is, where did she get it? Where did she get all the Botox from? Don't you have to be like a doctor to order Botox?
We're good to go. And again, the question was simply, were there any corrections or errors you wanted to bring to my attention? Or not?
No.
Thank you, Mr. Chinsky. And in regard to the PSI and written report, the written agreement that was filed with the court, and the acknowledgement of rights form, as you indicated, those are all written in English. And as you went through those documents, did you have the ability to read those either in English or have them interpreted for you in Spanish? And did you fully understand all of those documents, notwithstanding the fact that they're in English?
Yes.
Thank you. From the state, anything else in support of the plea?
No, Your Honor.
Mr. Tuschinski.
No, Your Honor.
I will note that this is Ms. Cabot's first criminal offense as listed in the PSI and written report. Deem that the terms of the plea are appropriate and accept the terms of the plea. The conviction for practicing medicine without a license will be entered as a level 5 felony. There will be a 2-year suspended sentence imposed effective today, and you will be going to the probation department to formally begin your supervision today. There will be the $1 fine plus court costs imposed as well. As it relates to the financial obligations in the case, as well as any bond, there was a $10,000 cash bond. Mr. Tuschinski has asked for $5,000 of that to be assigned to his office, and I will be honoring that bond assignment. And so $5,000 will be going to Mr. Tuschinski for payment of his fees. The remaining bond will be applied towards fines, costs, and probation fees, which will satisfy all of your financial obligations to the court. And the remainder will be returned to the cash bond depositor and or the defendant. Any questions over the conviction or the sentence that's been entered, Ms. Cabot? As I indicated, you'll be going from here to probation. My bailiff will provide you an information sheet about the conviction and sentence that has been entered. I wish you the best of luck.
Thank you.
There you go, guys. Do not administer Botox if you're not allowed to administer Botox. Even though I bet the money is really good. All right, Bobby. I think this is Indiana, Bobby.
That she's getting ready to take off her head because she's in court. Thank you so much. State your name.
Oh, this might be Georgia.
All right. And Miss Williams, are you able to hear me? I'm sorry?
Yes.
Okay. You're here this morning for your initial hearing. State your full name for me.
Toya Williams.
And is your name spelled Latyoyawilliams? Is that yes?
Yes.
And is your date of birth September 27, 1988?
Yes.
All right. Ms. Williams, you've been charged with count 1, public nudity, a class B misdemeanor, and count 2, disorderly conduct, a class B misdemeanor. Charging information reads for count 1 on or about December the 13th, 2025. Latoya Williams did knowingly in the 400 block of North Grant Avenue, a public place, appear in a state of nudity, expose buttocks with the intent to be seen by another. Count 2 on or about December the 13th, 2025. Latoya Williams did recklessly, knowingly, or intentionally make an unreasonable noise and continued to do so after being asked to stop, all of which is contrary to the laws of the state of Indiana. Now, Ms. Williams, the class...
My damn dog is doing both of those things right now. Right now.
Class B misdemeanor carries a maximum penalty of 180 days in jail with a maximum fine of $1,000. A plea of not guilty will be entered for you today. You have the right to a public and speedy trial by jury. You have the right to confront and cross-examine witnesses against you. You have the right against self-incrimination, which means you do not have to say anything that is against your interest. You have a right to bail, and you have a right to be represented by an attorney. If you cannot afford an attorney, the court will appoint an attorney to represent you in this matter. Additionally, because you've been charged with a Class B misdemeanor, you're entitled to what's called a bench trial, where the judge will hear the evidence. You would like to have a trial by jury. That request must be made in writing at least 10 days prior to your first court trial setting. If you fail to make a timely written request for a trial by jury, you will waive your right to a trial by jury. Do you understand what I've explained to you so far, Ms. Williams?
Yes.
Now, excuse me, Ms. Williams, do you have the money to hire an attorney to represent you in this matter?
No.
Are you working?
Yes.
Where do you work?
I work at Allison Transmission.
And is that a full-time job or a part-time job?
Full time.
And how long have you been there?
8 years.
Okay. And do you get paid weekly or bi-weekly?
Weekly.
And what is your take-home pay approximately every week after taxes?
$1,000.
Okay. Do you support anyone other than yourself?
Dwight, thank you so much. Thank you so much. I appreciate it.
I'm sorry, I couldn't hear you.
Yes.
Who do you support?
My 2-step kids.
How old are they?
13 and 15.
Okay. Well, ma'am, you are not indigent for the purposes of being appointed a public defender, so you will have to hire an attorney to represent you in this matter. How much time do you think you're going to need for that? Think you can have someone hired within 30 days?
No, I don't have the money.
Do you think you can have someone hired in 45 days?
I don't have the money.
Well, ma'am, then let me ask you some additional questions. Do you rent or own where you live?
Rent.
And how much do you pay in rent?
$1,200.
What are your other expenses?
Groceries, electricity,
Well, hold on a
car,
second.
insurance.
Ma'am, how much do you spend approximately every month in groceries?
$400, $500.
And what else did you say you have an expense?
Electricity, bills.
How much do you spend in electricity every month?
$300.
What other bill did you have? I'm sorry.
Car note.
How much is your car?
Be glad it's $1,200 a month. Because if you look at Australia, it's a week. It's $1,200 a week.
Every month.
$1,000.
Is your car insurance included in that amount?
No, it is not.
How much is car insurance?
$400.
What other expense do you have?
Remember all that I listed. Cell phone bill.
How much is your cell phone bill?
$100.
Any other expenses?
What all did I list? I mean,
I'm sorry, did I miss anything?
I was just thinking.
Okay. So at the end of the month, how much would you say that you have left to spend? That
Maybe $300, $400.
All right. Court will appoint the public defender's agency to represent the defendant.
Right here, Judge.
Is that Mr. Redmond? All right,
Yes.
Mr. Redmond, good morning. This is
Morning.
Ms. Williams. The omnibus date is April the 11th. Ms. Williams, that's not a date for you to come back to court. It's a date for the lawyers to know for filing certain motions and defenses. How can I help you, Mr. Redmond?
So I just asked for a pretrial conference in due course.
Pretrial conference, April 29, 8:30 in the morning, in person. All right, ma'am, we'll see you on that date and time. Keep in touch with your lawyer.
Thank you.
I think that was Indiana, Bobby. So, there you go. All right. This doesn't have a verdict, but it's a great jail story. I just think it's a great jail story. So we're going to watch it. Right, Jen?
0505 MR 080814, State of Indiana versus Arian Fuller. Mr. Fuller, raise your right hand to be sworn, please. Do you swear affirm testimony about to give us the truth, whole truth, and nothing but the truth?
I do.
Go ahead and say your name for me, please.
Arian R. Fuller.
All right, you're here with your attorney, Ms. Turner, and states here by Mr. Gallo, and your attorney filed a motion to modify. I will confess, Ms. Turner, I haven't had an opportunity to review those because I was in court all morning, so I haven't had an opportunity to review what you sent me today, but it will be on my list of things to do. Do you have any evidence you wish to present today?
Judge, I'd like to take some testimony from my client.
All right, he's been sworn. Go right ahead.
So I think she's trying to get him out of jail earlier than he's allowed to get out of jail.
Thank you. Arian, let's start with, how old were you when you committed this offense?
I was 17 years old.
Okay. And you were sentenced to 55 years, is that right?
Yes, ma'am.
Okay. Since you have been in custody at the Department of Corrections, can you just give us a brief summary of the things that you have accomplished while you've been there?
Yes, I have. Well, the first thing I did was get my GED. And I also, at the same time, got Thinking for a Change, which I wasn't credited for. I have building trades. I have anger management. I have moral recognition therapy. I have a non-accredited college course in childhood psychology. I have business technology. I have married while incarcerated. And I believe that may be it. If I'm not.
Yep. He sure did. He sure did get married while he was in jail. Yep. For a long sentence. He wasn't just in jail for a few years. 55 years, I think, is what he got.
Okay. And in looking at your progress report, there are a number of conduct write-ups since your time in the Department of Corrections.
Yes, ma'am.
Uh-oh.
Yep, I think she froze. We'll give her just a second. Sometimes it comes.
What is it that you want? Did I freeze? Am I
Yeah,
back?
you did. You froze when you said you had a number of conduct reports, and then we lost you at that moment.
Okay. All right. Arian, given the number of write-ups that you've gotten since you've been in the Department of Corrections, why do you think that the judge should modify you out?
It's hard to say why the judge should modify me. That's hard to answer, but I could elaborate on the journey from the beginning to where I am now and why I accrued or how I accrued so many conducts. And the reason varies over time because I spent such a long amount of time in prison. Prison kind of happened in phases for me. So in the beginning, the reason was different than, a little further on, such as in the beginning, I was angry, I was scared, I was confused, and I rebelled a lot because of that. And I really just didn't understand my circumstance. I was in a situation where I had so much time looming over my head that it was more time than I could understand. And to my young mind, I thought I had life and I really didn't care about much. I was hopeless. So I rebelled and I didn't care much. And over time, that became a condition. And I did in the beginning what I thought it took, and at times what it took for a young person like me to survive around in an environment with hardened individuals that I had not been accustomed to being around. And what I didn't realize is that 5, 10, 15 years of practicing this mind state, it became a conditioning. And when by the time I realized that I was in that condition, I had to start the process of trying to peel back the layers and understand what it took to reverse the effects. And that was a journey in itself. And it's still a journey to this day. I won't lie. It's not easy, even to this day, but the reasoning is not the same. So it's just been a journey for me. It's been a journey trying to figure out how to become a man with the examples of men in prison and in the environment of a high security prison. It wasn't easy at all. And I didn't always make the right decisions. And I didn't always understand what the right decision was. But today I do understand what decisions I need to make for myself and for my family, and to be a productive member of society overall. I'm still doing the work that it takes every day. It's kind of like being an addict, where, you know, they say once you're an addict, you're always an addict. It's kind of like that for someone in my position. It's everyday work. It requires me to be conscious and aware every day of my thoughts, of my actions, of my surroundings. I have to think for other people. It's a task, and it's the biggest task that I've ever faced. And even still today, I don't always get it right, but I'm always working. I'm always conscious of what's happening and what I'm doing. So I try to limit the self-harm that I do to myself and how that affects others. I'm aware now of how my actions affect others. And that's something that I was not necessarily aware of when I was a teenager and I was a young adult. And it's something that I've grown exponentially in that area. So, you know.
You have a lot of family support, is that right?
I do. Yes, I'm very blessed in that way.
Okay. Have you thought about what you would do or what the plan would be if you were to be modified out? Is there a plan for housing? Is there a plan for employment?
Yes, ma'am. As far as housing goes, I was fortunate enough to be a part of my wife building us a home, and in a suburban area called Maryville, not very far from where I was raised. And so I would be going home with my wife to the home that we built.
Yep. You hear that, guys? While he was incarcerated, he got married to a woman who is buying a home for him to go to when he gets out of jail. That's what he did with his life while he was incarcerated.
As far as job opportunities, my brother, my wife, my mother-in-law being having the longest tenure, have been working in a steel mill for a very long time and has a lot of seniority. And I would be able to obtain employment there. But my real goal is, my passion is youth advocacy. I want to be in a position to stop someone from coming down the same road I did as a kid, because I realized the mind state that I was in. I didn't know that this could happen. I didn't know how bad it could get for my life. I didn't understand this. And I want to stop someone and educate someone else so that they don't have to do this, because it wasn't necessary for me. I wasn't a bad kid. So that's my passion. But in the short term, I plan to work in the steel mills, or even to obtain a simple job. I would take a factory job, anything just to get my feet wet, so to speak, with being in a work environment and freedom. I've been in work environments and incarceration, but I'm sure it's not the same. But that is my plan in the short term, is to work in the steel mills.
Okay. All right. Those are all the questions I have, Judge.
Mr. Gallo, you have any
I
questions
do,
to answer?
Judge. So, Mr. Fuller, you stated that your conducts were the result of being young. Is that correct?
In the beginning, that was one phase of receiving conduct issues. Yes.
Okay. So, what is the explanation for the conducts from the possession of a controlled substance in December of 2024?
That is the result of alcohol use, and that's something that I picked up in prison. I was never an alcohol user. I'm sure, obviously, I was too young to. That's something I picked up in prison from being in isolation for so long. I turned to substance at one point to help me with my social anxiety and just to escape. I mean, I found myself at periods in my incarceration dealing with depression a lot. And unfortunately, in prison, there are not many outlets. And I turned to a not very good outlet at times, using alcohol to escape. And I was held accountable for that in that moment.
What about the other conduct from July of 2024 with that is an unauthorized organizational activity?
That was from a book that I was writing, well, attempting to write anyway, that I hadn't got prior consent from the warden, the superintendent for. So they held me accountable for that, because it's a rule that in order to write a book that contains any security threat material, anything like that, you have to have prior consent. And I didn't know that. So I went about the book. They discovered the book that I was
Thank you, Zach. Thank you.
writing, and they held me accountable for that. I was telling a tale of my life and how I felt as though my surroundings impacted me coming to prison, my road to prison.
What about the conspiracy attempting aiding or abetting a conduct from August of 2024?
That's a very complex situation. They moved a guy next to me in my bunk, and he was involved in a lot of stuff. And me being who I befriended him, and I got drawn into that. He was using my name to impress a lady officer, and she believed him. So when they everything got unraveled, she told them the internal affairs exactly what he had been telling her, and he was lying to her. And that came back to bite me. So,
So this report is from May of 2025. Have you had any conduct since May of 2025?
I believe I had last year. I had a conduct. I had a conduct last year. It was aiding and abetting in a argument. It was aiding and abetting an argument. I was attempting to defuse something, and I got in trouble for that. I was around the situation. It resulted in an argument, and I got held accountable for that.
Okay. How many times have you been placed in SEG?
Twice.
Okay. Judge, no further questions.
Thank you. Any redirect, Ms. Turner?
No, thank you, Judge.
All right, thank you. Any other witnesses you'd like to call, Ms. Turner?
No, thank you.
All right. Mr. Gallo, you have any evidence you wish to present, sir?
Judge, I don't have any evidence, just argument.
Hi, Seahawks.
All right. Then go ahead and do argument, Mr. Gallo.
Judge, at this point, the state would object to any modification of sentence. It looks like Mr. Fuller has about 10 actual years left. Normally in situations like this, when the court is considering a modification of what is the most serious offense in Indiana, the court looks for an exemplary criminal record or a record of conduct in the Department of Corrections. Mr. Fuller, since his conviction, has had more. I could count, but it would take a long time. Has had nearly constant conduct issues within the Department of Corrections. I don't believe that he has demonstrated the sort of record of rehabilitation that the court usually looks for in cases like this. Also, I have concerns about Mr. Fuller's reentry plan, specifically that it is sort of tentative. There's not a solid, I'm going to be working here, I'm going to be living here. This is, I'm hooking up with Recycle Force. I've got a sponsor on the outside. I've got a plan for substance abuse. I've got a plan for where I'm going to live. I am concerned about the reentry plan. I'm concerned about the constant conducts. And I'm concerned about, frankly, the nature of the offense. Judge, we attempted victim contact in this case. I just want to make the record clear. We exhausted basically every resource I have to try to track down next of kin. The fact of the matter is it's a 20-year-old case, and we couldn't track him down. Again, I'm not going to state what I think the victim would or would not say in this case. However, it is important to note that even though
So it sounds like he's already served 20 years, and it sounds like it was not murder.
Mr. Fuller was 17 at the time, he received the advisory sentence, which I believe is appropriate in this case based on the nature and circumstances of the underlying facts. So the state would sternly object to any modification in this case.
All right, thank you. Ms. Turner?
Thank you, Judge. I am asking the court to consider modifying the sentence. I understand that he did receive the advisory because he was a juvenile when this offense occurred. He has served enough time for the court to consider modifying him. My request is that the court would consider modifying him, basically stepping him down through community corrections, followed by a period of probation. I think the court could keep the advisory sentence, but fashion it in a way that allows him to transition back into the community. In terms of the state's argument of, expecting exemplary conduct in the Department of Corrections, when you're talking about a 17-year-old kid going into an adult prison, who has no prior criminal history, that's a big ask. It's a big ask. And I think that my client was very candid in his explanation about it being difficult adjusting to life in an adult prison when you were a kid, and just having the mindset, and it's totally understandable that at 17 you don't understand what 55 years looks like, and you think that that's it, that there's nothing more for you. And he talked about his journey, which I think is important, and I think that shows maturing, growing up. And so, he can't change the past. He can't go back and take away those conduct reports, but he can accept responsibility for them, which he has. And to be concerned about his reentry plan being tentative, this modification is tentative. It's very difficult to say, I'm going to set up this plan, I have this job lined up, and I have this lined up and that lined up, when what we're doing is having to make a big ask of the court to convict him in the first place. Whether or not he gets modified is tentative, but the fact that he has so much support, family support, I submitted letters of support. I think all that goes to show that he would have a good opportunity, a good chance to be a productive member of society, having as much support as he does. Based on all of those things, Your Honor, I would ask the court to consider modifying him, stepping him down through community corrections and probation.
All right, thank you. All right, as I said, I did not have an opportunity to review what you sent me today, so let me take what I've heard today, go back and look through the rest of the items. I'll take this under advisement, and I'll get a ruling out to you in the near future.
Thank you, Judge.
I don't know.
Thank you, everyone.
I can't
Thank you.
tell which.
You're welcome. Bye-bye.
Which side it's going to fall on. on that one. Kinsey's already served 20 years, but he does not have a stellar prison record. And but they might just want to get him out of jail. You mean they're all for giving people probation? I don't know. I don't know what they're going to do. This was Friday.
I noticed that I put the wrong thing on the P-food form. Yeah, yeah, my fault. Okay, no, I just fixed it. Okay. Thanks, guys. Okay, guys, you ready? Is this yours, Sean?
Yes, sir.
All right. You're Mr. Abdel? Or you're Mr. Abdel? And you are Mr. Taha? Each of you are charged with terroristic threat. You're facing up to, do you speak English? Yes, sir. You speak English? Each of you are charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On April 3rd in Harris County, officer dispatched a reference of a terrorist threat call. The complaining witness stated that his 2 dogs had escaped from the house and he and his kids began running down the street to find them. The complainant got to his dogs and started loading them into his vehicle when the defendant stated to him, this is the defendant, Taha, stated to him, I'm going to shoot your dogs, I'm going to shoot your dogs, I'm going to shoot you too, you fucking idiot, go back to your country. Co-defendant, Abdel, also stated, we're going to shoot you. The defendant stated this is the 5th time the dogs came into their yard. The co-defendant stated if the dogs return to his house that he will do what he has to do to protect his family.
Gentlemen, I'm going to find that there's sufficient probable cause to go forward with your cases. Each of you are now barred from speaking or having any kind of communication with the complaining witness in this case. If you violate these conditions, I will put you in jail. No more PR bonds for you. If you are in jail, I'm going to make your bond high. Do you understand? Yes or no? Yes. I'm going to protect my community at all costs. And if I have to put you in jail at a $2 million bond, I will do it in a heartbeat. You are not to be in possession of any weapons. Likewise, if I find that you have a gun or any kind of weapon, into jail you go. How old are you, Mr. Taha?
20.
Do you have the ability to hire a lawyer?
Maybe yes.
We will give you time.
Okay.
I'm going to have both of you sign a reset with Victoria. We are going to get you out of here to hire lawyers. When you come back, you need to have a lawyer, please. I'm going to have you take a seat in the jury box while we have bond conditions created for you to sign, promising us that you're not to have any contact with this person and not to be in possession of any weapons. Once you sign those documents, at that point, you'll be free to go. Be careful. I'm not going to warn you again. Do each of you understand?
Yes.
Come on.
All right, Judge, next is case 1 and 2. Alvarado, come on up. No, just a minute. Abdel first, is that you? Yeah. Okay, one second. Go ahead.
John, who did she say this was?
Alvarado.
You are Mr. Alvarado.
Yes, sir.
Sir, you're charged with interference with the emergency request for assistance. You are facing up to a year in jail and or a $4,000 fine. You're also charged with failure to comply or actually leaving the scene of an accident without exchanging information. On that one, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On April 5th, the officer responded to a call for service in Harris County, and while en route, dispatch informed him that the complaining witness advised that her intoxicated boyfriend had hit a parked vehicle. Dispatch then informed the officer that they heard an open line disturbance and a male voice yelling in the background. Upon arrival, officer made contact with the complainant who informed officer that she and the defendant were arguing, and the defendant became increasingly aggressive, slapping her hand at one point, causing pain. Complainant then advised that she called 911, and during the call, the defendant took her phone and threw it. Complainant's phone then rang when dispatch called the complainant back. The defendant grabbed the phone, allowed the complainant to speak with dispatch for a moment before taking the phone and threw it to the ground, causing it to shatter. As far as the stopping vehicle information, upon arrival, the officer observed damage to the passenger side of the vehicle. Officer made contact with the defendant, who informed the officer that he had 3 shots of alcohol at a family gathering, and affirmed that he did strike a neighbor's vehicle while he was driving. The defendant further advised that after he struck the vehicle, he did not make contact with the owner of the vehicle. Officer then spoke with the complainant, who informed the officer that she observed on her exterior cameras the defendant striking her neighbor's vehicle.
That's what I was about to say. How do they put him? So they're on camera with him?
Yes, sir.
Okay. Does he have a license to drive?
Let me write the judge.
Mr. Alvarado, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to give you a portable device that you're going to take with you everywhere you go to prove to me you are not consuming alcohol. I don't care what it is. You blow hot, I will put you in jail. Do you understand?
Yes, sir.
I will not give you any more PR bonds. If I have to put you in jail because you endanger my public, it's just not going to go well for you.
The license is eligible.
Okay. You're not allowed to drive unless you have a valid license. You must also maintain liability insurance. If you don't have insurance, then there's no driving. That is also a condition. Do you understand?
Yes.
Tell me about contact with the complaining witness. Does she want to have contact with him? Do we know?
As of now, Judge, we don't know.
Okay, at this point, until I know that she wants to have communication with you, I'm barring you from having any communication with her as well. Do you understand?
Yes,
no contact means no contact at all. I don't care if she reaches out to you. I don't care how, social media, phone calls, text messages. If she calls you, do not answer. If it's from an unknown number, hang up. If she texts you, do not reply. You understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Possible. I'm not in this position.
What do you do for a living, sir?
I'm a state person for activity seeking.
So you're not working at this time?
The parking garage.
How do you support yourself?
At the time, I was, that's my.
Stop. Just, it's time for you to get a full-time job. Don't go for the job of a CEO. You need anything that you can get at this time. Do you understand?
Yes, sir.
Okay. Deputy Williams will give you an application. I'm going to have you sign a reset with Victoria. I'm going to have you take a seat in the jury box. You'll meet with Veronica for your bond conditions, but I'm bringing you back in 2 weeks and I want to see what you have done to get a job. 30, 40, 50 applications. If you have done nothing, it's not going to go well between us. People who have too much time on their hands become self-destructive. We want you to be the best person that you can be, and it starts with getting a job and right here. Get it? Come on.
Did you want random testing plan or no? Just
Yeah, of course. Yeah. So, Ron, all of them, when I'm saying no alcohol or drugs, all of them random testing.
All right,
Yeah, yeah.
just top of page 3, as in Dia. Oh, we have to have Mr. Nolan. Oh, you just signed on, Judge. I didn't do it, so just.
Who?
Top of 3.
I see Mr. Newley. Okay, got it. We'll wait.
Okay, we'll wait for him.
Yeah.
Next judge is bottom of 6, Green. Green.
Green. Okay.
All right.
Move on.
Page 7, Haggard. Haggard.
Guys, when you come up, please come around this way. We do not want you near the DAs. Mr. Haggard, you're charged with 2 cases. You're charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. On the gun case, you're facing up to a year. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On April 5th in Harris County, officer observed a motor vehicle weaving in and out of the marked lane lines and failed to signal a lane change several times. Officer conducted a traffic stop. The defendant, the driver, had a strong odor of alcoholic beverage, red bloodshot eyes, and slurred speech. The defendant admitted to consuming alcoholic beverages and swayed when he walked. SFST performed 6 out of 6 HGN, 5 out of 8 walk and turn, 2 out of 4 one-leg stand. DIC was read and refused. Blood search was executed. Blood search warrant executed. Search incident to arrest of the motor vehicle found Smith and Wesson in the glove box and a 375 milliliter bottle of Hennessy half drum.
I see that he has an FSRA from about 1.5 years ago, 2 years ago.
Yes, Judge.
Was alcohol a factor in that one as well? Do we know?
No, sir.
And does he have a license, Sean?
He does have a license that's eligible. Alcohol is not a factor to go.
Mr. Haggard, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. You understand? You were ordered not to consume alcohol or illegal drugs, including marijuana. You will be tested. If you test positive, likewise into jail you go. No more PR bonds. Also, while this case is open, you're not to be in possession of any weapons. Do you have the ability to hire a lawyer?
Sir.
We will give you time. I'm going to have you go to Victoria Center Reset. You'll get with Veronica for your bond conditions. Don't drive a vehicle that doesn't have an interlock. I'm sending notice to DPS in Austin. Every police officer in the state will know. If you I'm just telling you what the conditions are. The logistics will be explained to you through pretrial services. But what I'm telling you now, every police officer in the state, if they pull you over, they're going to know that there's an interlock requirement. If they see that you don't have one, they will take you to jail.
How can I get it? How can I get it?
They will go through with you pretrial services. For now, let me have you sign a reset. We'll have you get with Veronica and then we'll send you on your way.
Right this way. Bring.
Can you file the paperwork, please? Victoria?
Yes, Judge, I'm doing it right now.
Thanks. Is this green, you said?
Yes.
Okay.
Bottom of 6.
Ms. Green, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. Where is this from, Sean?
Walmart, Judge.
Okay. Ma'am, as a condition of your bond, you're ordered not to go to any Walmart for any reason. That is a condition of your bond. If you violate this, you will be arrested. I will revoke your bond. Do you understand, ma'am?
Yeah.
Do you have the ability to hire a lawyer? You have a lawyer? Oh, who? Dunham. Okay. Dunham. They hired a lawyer. That's usually like Miss Hudson, I think. All right, so let's do this. I'm going to have you sign a reset. We will have you take a seat in your box while we generate your bond conditions. We'll wait for your lawyers to get here, and at that point, we'll have you speak to them.
What he said, we have a call set up for 1:30 because we talked about it all this morning.
So you haven't hired them?
I have. But we have our person who called today at 1:30.
Are they supposed to come here this morning?
And he said, just let the judge, let the person know that I hired them.
But you haven't hired them though. If you hired them, they would come on, they would sign on to the case. You have not hired them. You're going to, but you haven't.
Said the payment.
So just JJ.
Okay.
All right.
State's bond condition?
Yes, please.
All right, Judge, next is top of page 8. Jimenez or Jaime?
You can sign it just one.
Good morning, Mr. Jaimes. Do you speak English, sir?
Yes, sir.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. Is it the standard in the car and?
Yes, sir.
Same thing?
Odor of marijuana.
Okay. Does he have a license to drive?
I believe he does. Let me check it out. It is, Judge. It's out.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, and that is a condition of your bond. I don't care that you drove here. If you don't have insurance in your name, do not drive. If I find that you do, I will put you in jail. Also, will condition while this case is open, you're not to be in possession of any weapons. Do you understand?
Yeah, you're right.
Okay. Do you have the ability to hire a lawyer?
No.
Well, how do you support yourself?
I don't work.
Okay. What do you
I just
do?
go meet my
What do you do for a living?
worked at a tire shop, change tires, mechanic work, other stuff like this.
So Deputy Williams will give you an application. I need to know everything about you, where you live, who you live with, how much money you have coming in, are you married, any other type of income, and then I'll take a look to see whether you qualify. Come on. So no weapons and no driving without license in
Yes, sir.
please.
All right, Judge, top of 10, Marquez.
And then after this, let's hit Cena.
Yes.
Coming up. You are Mr. Marquez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On April 4th, the Harris County officer observed a vehicle on Sam Houston Parkway weaving in and out of lanes, failing to signal a lane change or turn. Traffic stop was conducted. Officer could smell a strong odor of alcoholic beverage from the defendant's breath and noticed red bloodshot eyes and slurred speech. SFSTs were conducted. 6 out of 6 HGN, 6 out of 8 walk and turn, and 3 out of 4 one-leg stand. DIC was read and refused. Blood search warrant was executed. Officers located a half-drunk bottle of tequila and several small shooters in the vehicle.
So you have a license to drive? Mr. Marquez, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
You are not allowed to drive unless you have valid liability insurance in your name as well.
Yes, sir, it's eligible.
Okay. Do you have the ability to hire a lawyer?
Right in my house.
How do you support yourself, sir?
I work, I'm a laborer,
Okay. What kind of money do you make a month?
about 2,200 a month.
And who do you live with?
Well, she know my wife, we've been living together for years. So I say,
Does your wife work as well?
yes.
Okay. Chances are you're probably not going to qualify for a court-appointed lawyer. You have to be at the federal poverty guideline to qualify for an appointed lawyer where you're making $15,800 a year. Do you understand?
Yes, sir.
I mean, if you want, I can take a look at your financials, but I'm going to need how much you make per month. I'm going to need to know how much your wife makes per month, any other sources of income. So it's up to you.
So I have time just to find the lawyer.
Of course, we'll give you as much time as you need, but this is a DWI. I don't sit there and wait a month, 2 months because you're only going to hurt yourself. You need to get on it quick. There's a lot of timing requirements. So you understand?
Yes, sir.
What do you want to do? Do you want to try to apply or do you want to just go look?
Store's open.
Okay. We're going to, like I said, we'll give you time. I'm going to have you go to Victoria, sign a reset. You'll get with Veronica for your bond conditions and then we're going to get you out of here. Do not drive a vehicle unless it has an interlock. Do you understand?
Yes, sir.
I don't care what you have to do. I don't care what the emergency is. You cannot justify driving any car unless it has an interlock. All right? Okay, come on.
All right, Judge, next is, let me see, page 11, 12, Miller. Go ahead.
Hey, is he on call me?
I'm not sure.
Veronica, yes.
You say yay?
Yes, I believe so. Not sure.
Thank you. You're the best. Good morning, Mr. Miller.
Yes.
Sir, you're charged with 2 counts of illegal dumping. Excuse me, 2 counts of illegal dumping. On both of those, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Well, I don't think we need to do probable cause. The only condition I'm going to place on you now is do not pick up any new cases. Do not dump illegally. Keep my city clean. Otherwise, I will put you in jail.
Yes.
There's no more. This is not a revolving door. You will not get PR bond after PR bond. If I have to put you in jail, I'm going to make your bond high. Do you understand?
Yes.
Does he have a license to drive?
Check it. Yes, sir, it's eligible.
Okay. You're not allowed to drive unless you have valid liability insurance as well in your name. If you don't have car insurance, then don't drive. That is also a condition. Do you have the ability to hire a lawyer?
No.
How do you support yourself, sir?
I'm homeless.
Okay. Deputy Williams will give you an application. I need to know everything about you, and then we'll take a look to see whether you qualify. Any sources of income, anything I need to know, and then we'll take a look. She will give you an application. I'm going to have you sign a reset. Then we will have you take a seat in the jury box while we get your bond conditions. Do not leave until you come up here and sign the conditions. Okay? All right. Come on.
Was that state's bond condition?
Yeah. Is the co-defendant? Oh,
Open one.
got it. No illegal dumping.
Approaching for page 9, slide.
Hi, Sina. Happy Friday, man.
Happy Friday, sir.
Is it Lee or Lai? Lai, okay. Good morning, ma'am. Ma'am, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You're facing up to a year in jail and or a $4,000 fine. Do you want to hear probable cause or do you want to waive it?
The only reason we might want to is the interlock situation, since she's a .16, we think the actual stop is not valid.
My only concern are several. Number one, any prior to DBIs. Number two, are they consuming allegedly while driving? Do they have alcohol in the car? Unless those things, yeah, usually anything?
Oh, no.
No alcohol in the car, no crash, Your Honor.
Okay, so I'm not gonna put an interlock. Miss Lee, I am going to order you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be tested if I find that you're using, and I don't care what the excuse is, I will put you in jail. As much as I love him, I don't care. You use, it's just not gonna go well for you. You understand? Because you have a lawyer, I will waive your appearance, meaning you don't have to waste your time coming to court, but you must stay in touch with them and they'll tell you if and when you have to come back to court. For now, we'll have you sign a reset. You'll get with Veronica for your bond conditions and then you're free to go.
Thank you.
All right. Great to see you. You too.
I'll get you this done in just a minute. All right, Judge, bottom of 10, Mendez.
Yeah, it's
You speak English, sir? Mr. Mendez, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. Anything you think stands out in this thing?
Nothing stands out, Your Honor.
No.
Donuts in the parking lot.
Okay.
And this license is.
Wonderful. Mr. Mendez, as a condition of your bond, I'm ordering you not to participate in these types of activities again. Reckless driving, donuts, street takeover, racing. If I find that you do, first, I will revoke your bond and put you in jail, and then I will take your ability to drive away. Do you understand? Living in a city as big as Houston without the ability to drive blows, especially if you have a car. Do you understand? You are not allowed to drive unless you also have liability insurance. You must maintain car insurance, and that is also a condition of your bond. How old are you, sir?
18.
Did you want to apply for a court-appointed lawyer?
Yes.
Okay. Deputy Williams will give you an application. I'm going to have you sign a reset, and then we'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Come on. You know it.
Yes.
Go ahead and sign it. All right, Judge, bottom of 12, Morales, come on up.
Please add liability insurance as well.
Yes.
Okay. Did you say Morales?
Yes, Judge, bottom of 12.
We will hit you up next. You speak English, sir?
Yes, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. Anything aggravating?
Nothing in particular, Your Honor. I'm running his license right now.
No prior to BIs?
No priors, Your Honor.
No alcohol in the car?
No.
Okay.
And this license is eligibility.
Okay, Mr. Morales, as a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs. You will be tested. If I find that you're using, into jail you go. I will revoke your bond. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
We will give you time. I'm going to have you go to Victoria, sign a reset. You'll get Veronica for your bond conditions, then we'll send you on your way. Do not pick up any new cases. Do not drive without car insurance in your name. All right?
Yes, sir.
Come on.
Right this way. All right, Judge Lynn is approaching on the bottom of 17. Eden?
Good morning, Ms. Edis.
Good morning, Your Honor.
Ma'am, you're charged with terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I guess, yeah, go for it.
Yes, Your Honor. On March 9th, 2026, in Harris County, Texas, officers dispatched to a family disturbance call. Complainant, defendant's husband, stated defendant had been aggressive and crazy for a while, showed officer a video of an incident that occurred on November 29th, 2025 with the couple arguing. The video showed defendant grab a knife and state, quote, "I will kill you," while holding the knife. Witness, defendant's son, got in between the parties and grabbed the knife out of defendant's hand. The defendant felt in fear for his life.
Okay. Ma'am, I'm going to find that there's sufficient probable cause to go forward with your case as a condition of your bond. I'm ordering you not to be in possession of any weapons whatsoever. Do we know whether he wants to have contact or not?
Your Honor, I believe the complainant has reached out to our office and stated he doesn't want to pursue charges, but I haven't spoken to him personally.
Okay. We don't know for sure. As a condition of your bond, I'm ordering you not to have any contact with this person, and I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Mr. Vives as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harass behaviors. You cannot be in possession of a weapon or go within 200 feet of the Bachman house. If you violate this court order, the state will file additional charges against you. A violation of a protective order is one of the worst misdemeanor cases you can pick up. Please do not violate these conditions. If I have to put you in jail, there will be no more PR bonds. You understand, man?
Yes, Your Honor.
Okay. So if you guys are able to, speak with the complaining witness at some point this morning, then we might be able to modify. But until I know what he wants, 100%, I'm going to order no contact. I always like to, follow the complaining witness's wishes. And until I know that with certainty, just don't have any contact. All right.
I understand, Your Honor.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but they'll tell you if and when you have to come back to court. So just stay in touch with them and they'll tell you when you have to come back. We'll have you sign a reset. I'm going to have you take a seat in the jury box to wait for your bond conditions, ma'am.
Thank you, Your Honor.
Please. Yeah. Oh, okay, great.
All right, Judge Papa Ward V. Pennington, come on up.
So can you file no contact and no weapons?
Yes, sir.
Please.
Ms. Venus? Sorry.
Who's the next person? What's the last name? All right, Mr. Pennington, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. Does he have a license?
I'm running it right now. Your Honor, to confirm. License is not eligible, Your Honor.
You are not allowed to drive, Mr. Pennington. I don't care what you have to do in this life. I don't care that you have to go to work. I don't care that you have to do this or that. I don't care that you need groceries. Do not drive. Do you understand? If you do, you will be looking at a lot. I'm going to have you sign an affidavit with me today. This is a promise that you're going to swear to us that you're not going to drive. I don't care what your justification is. You drive, you can be facing 180 days in jail every time you drive. Do you understand?
Yes.
We are going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. I'm going to have you sign a reset. We'll have you take a seat in the jury box while we get your bond conditions. Once you sign them, at that point, you'll be free to go. Come on.
No driving, Your Honor. All right, Judge, no driving.
And then no driving. Yeah, no driving at all.
Oh,
Hi, Herman.
no, it's not an agreement. It's a THA.
Oh,
What's the last name?
Silver.
Yeah, it's.
Can I address the bond conditions as well?
Yeah, but let me get through.
Sure. I'll speak to it.
All right, Judge, we have a Spanish arrangement on page 4.
Please.
Nunes Garcia. Go ahead, defendant.
Solo mira el juez y le contesta el teléfono.
Garcia.
Buenas. Yeah.
Buenas Garcia.
Okay.
Yeah.
Sir, you're.
Señor Buenas.
Yeah, that's right. Okay. Sir, you're charged with driving while intoxicated. You were facing up to 6 months in jail and or a $2,000 fine. Anything that we need to know about?
Nothing in particular, Your Honor. No criminal history.
I see that he has a prior FSGI. Was there alcohol involved in that? And does he have a license to drive?
His license is eligible, Your Honor. On the FSGI, there's no indication of alcohol.
Mr. Duenas, as a condition of your bond, I'm warning you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I will randomly test you. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds for you. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they may very well put an immigration detainer on you, and then you will be stuck in custody for many months. You understand?
Yes, sir.
Okay, you have the ability to hire a lawyer.
Yeah.
Okay, we will give you time. I'm gonna have you go to Victoria, sign a reset. You'll get with Veronica for your bond conditions. You are not allowed to drive unless you have car insurance in your name as well. If I find that you drive without insurance, it's not gonna go well for you. All right.
So that was the last one for now.
Got it. Okay, Herman, ready?
I have two, Judge.
Sure.
First one that's here is Mr. Silvernail.
Okay.
Judge, there was some confusion on the bond conditions. I just want to make sure we address that, so there's no confusion for Mr. Silvernail as well. May I come up?
Sure.
Because he got a copy that wasn't signed by him, but I saw in the images that there was something. So
Coming up, sir.
am I correct, is now no contact? And then the way the bond conditions were worded was kind of funky as well, so I just want to make sure everyone's clear on that.
Your Honor, I don't believe the state would ask for additional bond conditions, a GPS monitor and a victim bracelet, just because he's on deferred for an AFM with the same complainant.
The impeding breath, is it also the same complaining witness?
Well, it was reduced down to your court. It's out of your court.
Yes, right. It was refiled.
He's almost, and he's gonna finish in May, Judge.
Great, but nevertheless, we
Yeah.
still have a new case with the same complaining witness. There's no contact whatsoever.
Yes, we're okay with that, Judge.
Sure. Do we have any allegation of, I don't remember about the harassment. Is the harassment that he's going to the house or allegedly or
You
calling
didn't
or
hear
what?
probable cause. I think it was on Tuesday.
Oh, I was out,
Yes,
right.
yes, if you want to hear probable cause.
I guess so. Go for it.
Yes. On March 30th, 2026, in Harris County, Texas, officer was dispatched to a family disturbance call. Officers made contact with complainant who was standing at the front door of her residence. Complainant stated defendant arrived home from Louisiana and demanded that he wanted his gun. Defendant started raising her voice and cursing at her. Complainant was scared to give him the gun due to prior assaults and defendant suffering from PTSD.
Yeah.
Complainant stated she would not give him the gun back. Defendant stated, quote, "Give me back my gun or you'll see what will happen." Quote, "I will ruin your fucking life." Quote, "Should I rip this house? Should I rip this house and find it?" Then proceeded to run towards complainant, jumped on top of her, mounted her, and called her.
This isn't a harassment case?
Yes, sir.
As a condition of your bond, I'm going to put a GPS monitor on your ankle and have a 1,000-foot curfew from this person. Mr. Silvernail, let me give you some perspective. You are on deferred, and one of those conditions is no weapon. If I find that you have a weapon, you are looking at an entire year in jail. Do you understand?
Yes, sir.
If you so much as have any contact with this person. Yeah,
That'd be agency paid, Your Honor.
of course.
Thank you.
Yeah, 1,000-foot, with the,
The domestic violence?
yes, so that she can be put in notice if he goes anywhere near her.
Is it
That
just
means
a
place of
residence?
work, place of residence, anywhere she is. If you go within 1,000-foot of her, it's not going to go well for you. I've made people's bonds millions of dollars in this court because they seem to think that, do you understand?
Yes, sir.
So do me a favor, please. Will you reach out to her, let her know the conditions that we place so that she knows if anything should happen, then to
Just, I can make the court aware that I've spoken to her yesterday, and I was going to tell her what happened in court today.
Okay, right. I don't want them
I'll make her aware.
near, and I just please admonish him if he's
He understands.
a weapon.
We've spoken about it.
God save the Queen. Okay. All right, go ahead, take a seat for me. You'll meet with Veronica here momentarily. Who's number 2?
Ms. Watson, I think she's on Zoom or should be in the waiting room, hopefully. Yeah.
Not yet. Sorry.
Okay, I'll be back.
Just, let me see if I have your, no. Let me see, Herman, let me see if I have your cell phone, and then I will reach out to you. Let me see. What, here, give me your cell phone. I didn't talk to you enough that if you give it to me, I'll text you.
Yeah, I'm just letting my staff know.
Well, I'll text you as soon as she gets here.
Yeah,
And then
but
I
I
can.
can them to contact her and see what she got.
Okay.
Want me to just write it down?
Yeah, write it down there. I'm gonna program it in my phone so I have it and then I can reach out to you, but she's not here at this point.
Eligible. 6529.
Yeah. Oh, that's a 6529?
Yes, sir. That's why I stated.
It was like a doctor or something. Huh? Oh, Herman.
Yeah. Yeah.
I'm sorry, I totally forgot. Silvernail, come up. So he was on deferred. You picked up a new case.
Yes, sir.
They filed a motion to revoke, and I just signed it.
Okay.
You're going to jail right now. Sorry, buddy.
It's about what we talked about the week.
You were ordered not to pick up a new case. I don't know why it didn't even occur to me, but yeah.
Made him aware.
Yeah. Okay.
And that's how we're going to end it. He thought he was fine. He goes to jail. Oh, that would suck. That really would suck. All right, guys, we made it to the end. We got our updates. We got our defendants arguing with the judge. We got some Judge Fleischer. I will see you all in about 6 hours-ish, sort of, kind of. 7 hours? I don't know. We're going to see each other again very soon. If not, I'll see you next time I stream at night, which is this Wednesday, because I am not on the schedule for Wednesday night this week. Boom. Which sucks, because I love making money. But it's fine. I will see you all in a couple hours. Go take a nap. Drink some vitamin C or something so you're nice and ready. Bushy-eyed and bushy-tailed. Fresh-eyed and bushy-tailed. Mary Brown. Hi, Mary Brown. All right, guys. Behave. All right? Dwight, it was good seeing you again. See you all later. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's Come and see for yourself.